Introduction to Public International Law, Definition, and Historical Developments. Definition of international law. Public international law is that body of law which is composed of the principles and rules of conduct which states feel bound to and do observe in their relations to each other. It also includes rules of law relating to the function of international institutions or organizing their relations with each other and the states and to the individuals, as well as certain rules of law relating to individuals and non-state entities insofar as the rights and duties of such individuals and non-state entities are the concern of the international communities. This definition covers different developments which have qualified traditional conception of international law as purely a system of rules and principles that are applicable to interstate relations on the basis of either state practice or international multilateral treaties. Regional institutions and organizations are governed by regional international law rules as opposed to general rules which are of universal application. Further, there has been a general international movement to protect human rights and fundamental freedoms of individuals, the creation of new rules for punishment of persons who have committed international crimes, environmental management and use of the sea, super-adjacent airstrips and the outer space. Private international law. Conflict of laws has little to do with public international law. Conflict of laws is that part of the private law of a country which deals with cases having a foreign element, that is to say, contact with some system of law other than that of the forum state. Such a contract may exist, for instance, because a contract was made or has been performed in a foreign country, or because a tort was committed there, or because some property was situated there. The parties to a particular case or contract are non-nationals of the forum state. For example, divorce cases. Conflict of law is a necessary part of the domestic law of each country because different countries have different legal systems containing different rules, while public international law seeks primarily to regulate relations between sovereign states amongst inter se as well as other international law persons. Historical developments of public international law. Contemporary system of public international law is normally traced back in terms of its order and structure to the Peace of Westphalia 1648, which marked the end of the 30 Years' War in Europe. However, it was not then that international relations started. This was because evidence was produced of beliefs of rules and procedure regarding international law dates back over 5,000 years. From the earliest times, rules of conduct to regulate relations between independent communities in their usual were not felt necessary and emerged from usages observed by these communities in their usual relationship. Treaties, immunities of diplomatic envoys and certain laws and usages of war existed in the Middle Ages before the dawn of Christianity, for example in Egypt and India. Around 2100 BC, a solemn treaty was signed between the rulers of Lagash and Umma, the city-states situated in the area known to historians as Mesopotamia. It was inscribed on a stone block and concerned the establishment of a defined boundary to be respected by both sides under pain of alienating a number of Sumerian gods. The next major instance was in 1400 BC, where the Egyptian pharaoh Ramses II concluded a treaty of peace, alliance and extradition with the king of Cheta, which recognized territorial sovereignty over certain areas of each ruler and provided for the extradition of refugees and the exchange of diplomatic envoys. Once Rome became an empire, the Romans organized their relations with foreigners on the basis of jus officiale and jus gentium. The jus officiale consisted of religious rules which governed Romans' external relations and formal declarations of war which inter alia recognized the inviolability of ambassadors and was at the origin of the distinction between just and unjust war. On the other hand, jus gentium was a Roman solution to the necessity of regulating legal relations between Roman citizens and foreigners as Rome expanded. Jus gentium simplified rules to govern the relations between foreigners, and between foreigners and citizens. From ancient Rome, international law also inherited the doctrine of the universal law of nature known as natural law, which was developed by the Stoic philosophers of ancient Greece and adopted by the Romans. This doctrine considered law as the product of right reason emanating from assumptions about the nature of man and society. Because natural law is the expression of right reason inherent in nature and man and discoverable by reason, it applies universally and it is unchanging and everlasting. Reference must also be made to the growth of Islam. Its approach to international relations and law was predicated upon a state of hostility towards the non-Muslim world and the concept of unity, Dar al-Islam, as between Muslim countries. The Middle Ages were characterized by the authority of the organized church and the comprehensive structure of power that it commanded. All Europe was of one religion, and the ecclesiastical law applied to all, notwithstanding tribal or regional affiliations. For much of the period, there were struggles between the religious authorities and the rulers of the Holy Roman Empire. These conflicts were eventually resolved in favor of the papacy, but the victory over secularism proved of relatively short duration. Religion and a common legacy derived from the Roman Empire were strongly unifying influences, while political and regional rivalries were not. But before a recognized system of international law could be created, social changes were essential. Of particular importance during this era was the authority of the Holy Roman Empire and the supranational character of canon law. In the Middle Ages, two sets of international law, namely lex mercatoria, law merchant, and the maritime customary law, developed to deal with problems that transcended international boundaries. With the revival of trade in the 10th century, merchants started to travel all throughout Europe in order to sell, buy and place orders for various goods. These commercial activities required the establishment of a common legal framework. Out of necessity, the European merchants created their own rules of conduct on fair dealing, which formed lex mercatoria. During the same time, maritime customs and usages were formed. The high seas were no man's land, but with the development of maritime commerce it became necessary to establish some rules and standards. The rules of the high seas were based on the Rhodian Sea Law, a codification undertaken under the Byzantine Empire, were compiled into widely recognized collections that became accepted all through Europe. The Middle Ages also saw the rise of nation-states that led in turn to the process of the formation of rules of customary international law from usages and practices followed by such states in their mutual relations. With the rise of the modern state and the emancipation of international relations, the doctrine of sovereignty emerged. This concept, first analyzed systematically in 1576 in the Six Livres de la République by Jean Bodin, was intended to deal with the structure of authority within the modern state. Bodin, who based his study upon his perception of the politics of Europe rather than on a theoretical discussion of absolute principles, emphasized the necessity for a sovereign power within the state that would make the laws. While such a sovereign could not be bound by the laws he himself instituted, he was subject to the laws of God and of nature.